Truly grateful to the Harvard Albanian Student Association, Harvard University, and particularly to Deni Hoxha for organizing this event and for offering me an opportunity to be on a panel together with Dr. Isa Blumi and a platform to discuss the legal aspects concerning the Cham issue. One of the most poignant features of addressing the past and gleaning historical truth is the urge to recognize and establish the legitimate search for justice for historically aggrieved and oppressed groups. Examinations of the past are often fraught with the perennially controversial nature of historical claims, as well as the debates surrounding the roles of different actors in committing, representing, and sometimes atoning for the historic wrongs. The daunting task of unveiling the truth, however, demands that we focus our inquiry primarily on documented records so as to better understand the past. Many aspects of the history of Albanian Chams have been little known or greatly misrepresented thanks to a multitude of measures and enactment adapted within Greece. The decades since the dreadful events of the Second World War have prompted among the Cham people much soul searching and a struggle for awareness. My presentation here today endeavors to shed light on both the history and the tragic event that have befallen the Cham community, as well as to bring into sharper focus the need to acknowledge the past wrongs. This presentation offers a general analysis of the legal tools as well as potential platforms to establish where the Cham issue can be litigated. The ideas presented here are my personal views and do not represent the opinion of any particular institution I'm associated with. They are based on my general knowledge of international law with the aim to evaluate how international law can be applied in cases of expulsion, murder, expropriation, revocation of the citizenship of the Albanian population of the region of Chameria, which was forcibly expelled by Greece in the period between 1915 and the end of the Second World War. The presentation contains two main aspects, namely a summary of the historical and legal framework of what happened to the civil, political, economic, as well as socio-cultural rights of the Cham population from 1915 until today, and the second aspect concerns an analysis of the legal and procedural matters as well as the potential forum where the Cham issue could be litigated. A long period of time has passed since the Cham community, then the Albanian ethnic minority in Greece, was subjected to the plans of assimilation and expulsion from the territory of their ancestors by the Greek governments that followed each other from 1915 until 1950, and which all pursued a strategy that had in common with elements similar to ethnic cleansing. It is important that we focus first on the historical framework, as this is closely linked with the legal dimension of this case. Following the Balkan Wars and the border demarcation of the independent Albanian state by the Conference of Ambassadors in London in 1913, the region of Chameria, which lies along the eastern coast of the Ionian Sea between Butrint and Bustrica to Preveza Bay, was annexed by Greece. This historical moment was characterized by the beginning of continuous pressure, a systematic policy by the Greek state and other ultra-nationalist forces to denationalize and ethnically cleanse this enclave. For that purpose, all manner of measures were used, starting with the imposition of heavy taxes, seizure of land, exclusion of the population from participation in public administration, forced interruption of education in the mother tongue, including within elementary schools, murder, imprisonment, violent punishment, and worst of all, the commitment of massacres. During the First World War, different waves of ethnic cleansing took place. They were further intensified by the Treaty of Lausanne in 1923, the result of which was the exchange of the population between Turkey and Greece, extending this way its consequences on the Albanian Cham ethnic minority, which for the purposes of the exchange was considered Turkish at the time. Furthermore, 1944 denoted also the culmination of this ethnic cleansing where the Muslim population of the Albanian ethnicity, the so-called Cham, were subjected to inhumane massacres, where 2,500 up to 3,000 individuals were estimated to have been killed. Among those were elderly, women, and children. As a consequence, the remaining Cham population of approximately 30,000 individuals were expelled on the basis of purported collaboration with Italians and Germans, which to this very day remains unsubstantiated. A considerable number of individuals lost their lives as the result of hunger and suffering during the march toward Albania. All this activity brought the dissolution of every aspect of the social fabric of this community, making it a subject of acts that constitute a violation of the principles and norms of international law. More specifically, this activity brought the following: denial of the right to life and physical freedoms of the Cham community, which included internment in 1940, massive murder in 1944 and 1945, as well as the forced expulsion in June 1945 of approximately 30,000 Cham from their homes. There exists an irrefutable archive that sheds light on the acts committed against the Cham community, against any efforts of denial. More concretely, in the archives of the Albanian Ministry of Foreign Affairs, there exist reports that refer to the activity exercised against the Cham community by the Greek troops. More specifically, they refer to the massacres in the city of Paranthia that took place on 27 January 1944, where it is mentioned that on that Friday about 2,500 reservist forces entered the city of Paranthia with the aim to use violence against the population of the city, which resulted in the killing and oppression of a considerable number of civilian population. A day later, inhabitants of the villages of Dragomia, Armini, Carbonar of the district of Paranthia were massacred, and about 600 men, 150 women, and minors are estimated to have been killed. Another document in this file is concerned with a massacre that has occurred in the city of Filati and surrounding villages in August 1944, during which time the innocent population was subjected to horrendous acts committed by the service troops. About 300 individuals from the region of Paranthia and Filati are thought to have left home and to have been imprisoned and tortured. About 250 women were estimated to have been kidnapped and physically violated by the Greek troops. January 1945 denoted the massive expulsion of the remaining of Cham population. The second concerns the denial of economic rights. The confiscation of properties and various expropriations were carried out on the basis of the agrarian reforms from 1923 until 1940, which were followed by other laws adopted in 1950 and 1960s. These legal acts attempted to erase in the context of the Cham, or let's say in the context of the Greek legislative framework, every right of ownership of the Cham community. The Greek legislative authorities have approved from 1940 and onwards a legal framework on the basis of which they have expropriated Chams permanently. From a legal standpoint, the existence of the so-called law of war between Greece and Albania has served as a tool to achieve Greece's objective to transfer the asset of ownership of the Cham community in Greece. The third component is the denial of political rights, political representation at all levels of the government, prohibition of the use of language, symbols, including above all the removal of the Greek citizenship, which was finalized with the Legal Acts of 1948, which in itself legalized the collective removal of Greek citizenship from all Cham Albanians expelled from 1944 through 1945. Documents are archived from the war, precisely from the war period, shed light on these discriminatory acts, which directly contradicts the principles of international law. More specifically, document number 59, issued on 11th of October 1938, by the head of Thesprotia Prefecture, expressly states that I have observed that the Greek language has not been used in the offices of the commune, government, and public spaces. It is said as this act is an offense to the eternal Greek language. On the basis of this document alone, all members of the Cham community were ordered to speak the Greek language both in public and private life, in bars, markets, as well as public offices. The fourth category concerns the denial of social and cultural rights, more specifically, the elimination of the national identity, monuments, and rich Cham folklore. All these denials reflect on the elements known today as characteristic or features that are in contradiction with principles of international law. Documents gathered from the archive of the League of Nations in Geneva and in New York, as well as documents of the British Mission from 1913 through 1960, obtained in the British archives, have an irreplaceable documenting value. Altogether, they shed light on the phases of the ethnic cleansing, forced expulsion of the Cham population from their homes. These documents play a very important role, at least on four dimensions. First, they represent the anarchy of the history of the Cham community in Greece, as well as the tragedy that has befallen this community. Second, since many of these documents are already public, they play an important role in raising national and international awareness of this cause, which is very little known or not at all known at international levels. Third, they constitute a potential base from where the Cham issue can be pursued from national as well as international tribunal or forum. Fourth, and arguably most importantly, this archive clearly demonstrates the violation of human rights as well as injustice afflicted to the Cham community, including the evidence of an expropriation and removal of the ownership rights of this community. I want to talk a little bit more specifically here about the development of international law and where the Cham issue falls within this spectrum. Prior to analyzing the international forums wherein the Cham conflict can be considered or litigated, it is important to address the dimension of international norms as the growing sensibility of the international community opposed to the violation of basic human rights. Every society, whatever in size, be that small or large, functions on the basis of a framework of principles. Legal and illegal acts are entirely reflected on the consciousness of the community. The law and the rights are elements sustaining the members of this community attached with the recognized and accepted standards and values. The system of law consists of a number of norms regulating the behavior and reflects the thoughts and concerns of a society in which this law is recognized and functions. Such a body of law, such group of norms, is reflected also in international law. However, the essential distinguishing characteristic is that the principal subject of this body, the essential characteristic is that the state, rather than individual, in that generic legal terms, it's important to understand the inherent and overt differences between exercising a right within a state and the rights regulating relations between states, international organizations, and in specific circumstances between individuals as subjects of international law. In this context, it's important to acknowledge that the judicial processes of the Nuremberg and Tokyo trials that followed the Second World War, in which the General Assembly and of the United Nations first recognized the need to establish an international tribunal in response to the crimes that have been committed or were committed in following the Second World War. The 20th century was characterized by a large number of crimes against humanity, war crimes, and genocide. It was precisely the nature and magnitude of these offenses that would act as a catalyst for the creation of the legal mechanism for bringing justice to those subjects and individuals and those countries that were subjected to the crimes of genocide, ethnic cleansing, war crimes, and crimes against humanity. In response to the tragic events that occurred in Rwanda, for example, or the former Yugoslavia, the Security Council adopted resolutions that led to establishment of the International Criminal Tribunal for the former Yugoslavia, International Criminal Tribunal for Rwanda. The same went for Sierra Leone, Following the crimes that were committed and the genocide that took place in Cambodia, we had further on the establishment of the extraordinary chambers in the courts of Cambodia. This further illustrates the growing interest and the sensibility of the international community regarding the injustice committed, and once again reinforces the idea that what was until yesterday, or what was considered a taboo topic, is now entirely possible, and that nobody, whether state or individual, cannot in principle escape justice. However, given that the mandates of these tribunals are of a temporary nature, a permanent tribunal or court was established in 2002 with complementarity jurisdiction, and that is International Criminal Court. In this context, it is worth understanding what happens during these proceedings at this level. Guiding through decisions on genocide, war crimes, and crimes against humanity, these processes prove that a high position can no longer defend an individual from prosecution. International law has already proven that those who bear the greatest responsibility for atrocities must be held accountable, and that guilt must be individualized and avoid the label of collective responsibility of different communities. These tribunals have laid the foundations of approved standards for conflict resolution and post-conflict development across the globe, and specifically the leaders suspected of atrocious crimes will face justice no matter what. How this development in a way of international humanitarian law, international criminal law, and international human rights law reflect upon the Cham issue. In the absence of a diplomatic front addressing this issue, which would require as a prerequisite a serious political commitment of the Albanian and the Greek government, the only viable option for this issue is to be considered within the framework of international legal forums. In legal terms, 3 points I think are of particular importance, on the basis of which a variety of platforms can be developed in pursuing this issue from a legal perspective. First, the recognition of injustice. In every post-conflict situation which follows serious violations of fundamental human rights and crimes against humanity, it is essential to demand the recognition of the committed injustice. This element, in my opinion, constitutes the origin of any possible legal analysis of the Cham issue. If the Cham issue were to be addressed by the International Court of Justice in The Hague, it is natural that any attempt from the Cham community should be supported by the leadership of the Albanian government and should be pursued as a requirement of the Albanian state before the International Court of Justice. The International Court of Justice has dual jurisdiction. First, in accordance with international law, judges rule on conflicts of a legal nature that are raised by a state, and secondly, it provides advisory opinions on matters of legal nature at the request of the UN or agencies authorized to make claims before this court. Second, bearing criminal responsibility. This would require the prosecution of individuals responsible in the event that an undertaking which would result from an orchestration made by various state structures. It is understood that the long period that have elapsed since the commission of these crimes makes it difficult, almost impossible, to pursue individual criminal responsibility in this case. Moreover, the principal element which can be hindered the pursuance of this issue in this forum is that of jurisdiction. In my opinion, this platform is merely or not at all feasible. Bearing civil responsibilities. Here I will dwell in particular on the restoration of the property rights and potential claims. The European Court of Human Rights would be an appropriate platform to pursue this matter legally. Different perceptions have been reported regarding international arbitration, which in an ideal world and democratic society where the acknowledgement of the past could be a part of the present and future, would be a potential platform. But the reality which we confront when one party denies the very existence of what has happened makes international arbitration not a realistic solution. In my concluding remarks, I would highlight that today exists an irrefutable historical archive which demonstrates potently, strongly, the offenses committed against the Cham community, resisting any attempts of denial. Reports describing the cruel crimes where thousands of individuals and civilians were killed and injured, tortured and abused in the camps and prisons, and thousands of others were driven from their homes, have far too long wailed in pain echoes of which resonate beyond the memories of these people, must necessarily extend and expand across the international community. Finally, a very important task that lies before the community, the Cham community, is the collection of evidence, material evidence that would constitute a very important basis from any legal initiative and standpoint. Here I refer particularly to the need to obtain interviews with eyewitnesses as required by international standards. A long time has passed, and the age of these witnesses make this task even more urgent. No doubt the legal proceedings resulting from the Cham issue will provide an opportunity to bring to justice those responsible for orchestrating these atrocities and to remove the shadow of doubt in ending the impunity of those perpetrators of violence. Thank you.